All right, well, let's get started. We're 30 seconds or a minute past the hour, so we can go ahead and get going. Well, thank you again for everybody for joining to the webinar today with Jason and I to talk about estate and legacy planning for rising professionals. I'll give you a brief background on myself. My name is Charlie Bray. I'm a partner and senior wealth manager out of our St. Joseph, Michigan office. So I run our team in Michigan. I've been with the firm for almost 10 years, or excuse me, 12 years now. Actually, in 20 days, it'll be 12 years. I started on a team in Chicago and then eventually moved back to Michigan once we started our family and got closer to both my wife and I's family here in Michigan.
And hello to everyone. My name is Jason Largy. I'm the wealth strategist for Curi Capital. I have been an estate attorney for about 20 years. Actually started my career in the Air Force JAG Corps, where I got some basic estate planning, and then transitioned to a private practice in Denver, Colorado, where I still live. After about 6 years of private practice, I moved over into this wealth management role where I try to be the conduit between our advisors and our clients and the various professionals that our clients meet with, for example, to set up estate planning documents.
Great. Thanks, Jason. So today we're going to discuss four key topics. First being why estate planning early matters, particularly for young professionals, young investors, young people in general. Why getting these documents and getting your plan in place early on matters a lot. How do you get the key documents that everybody needs? What that looks like in terms of protecting your income and assets with those documents and other planning tools. And then finally, planning for capacity and what happens to your dependents should anything happen. Again, Jason and I are really excited to go through some of these topics today. Although some of it is a little morbid, it is really important to cover these topics and have some of these key planning topics taken care of as you work through your career and can focus on what that all means. Again, Jason and I are really excited. There's two really important parts of this for me in terms of why we focus so much on estate planning as part of an overall financial plan. One, it's just really important work to do, but two, these are actionable items that you can take today based on some of the topics that we'll go through to actually knock these out. This isn't hypotheticals. This is really something that you can go and work with an estate planning attorney today, along with your Curi Capital or existing financial advisor to work through and get these taken care of.
Great, and thank you, Charlie. And I'll take it from here for a couple slides. A lot of times folks won't have an estate plan until a key event in their life. And I know even for me, I had probably drafted at least a couple thousand wills and powers of attorney early in my career, and it wasn't until a few years in that I decided, I'm doing this for everyone else, and I'm a young professional. I should probably have my own last will and testament. So what happens, people. You get busy with life, and you don't notice it, but one of the key things for an estate plan is you will create documents that will put people in charge of your assets. And sometimes we'll get questions about what happens if you don't have these types of documents. And there's things like a court process to if you don't have any of these documents. But why not put the people in place who will settle your estate, who will help if you are incapacitated and make decisions for you, things like medical decisions. We'll show how those documents work in a little bit. There can also be, I like to use the word intended versus unintended beneficiaries. So if you don't have an estate plan, the state that you live in has a statute that says it will go essentially down the line of your next of kin. And so some people might have siblings that they'd be okay that assets went to them if they died, but some people might have a partner, or they may have a child, or there might be different amounts and different percentages they want to go to different people. Also, asset protection is a good thing. Once you start putting an estate plan together, you start to find out how you can segment and put assets into different types of entities to protect your assets. So one thing a lot of folks will talk about is, and we'll focus first on the estate. So if something was to happen, and hopefully nobody on this call passes away anytime soon, but also you might have older family members that you may be responsible for some of these roles. You'll often hear about the probate process. And so if you have a last will and testament, or if you don't, an executor brings the last will and testament to the local probate court in the county that you live in, gets appointed, and gets a certain type of letter. It's usually called a letter testamentary or a letter of administration. So once you're appointed as the executor of somebody's estate, you actually own all of the assets that that person owned that didn't go through things like a beneficiary designation or any other process. And so the executor then takes an accounting, gets all of the assets, together of the estate, pays off any last debts, maybe like medical bills, funeral bills, things like that. And then the executor is then authorized to read the will, and sometimes things go equally to all the children or 100% to the surviving spouse, and the executor then can close the estate. Now, what a lot of people talk about is there's something called a revocable living trust. And a revocable living trust is a type of trust that's been around and been real popular for 30 or 40 years. It can help you and your heirs, if and when you pass, avoid the probate process. So if you create a revocable trust and you place your assets into it properly, when you pass away, your trust survives and becomes irrevocable, and then your trustee who you've named can take over and basically do everything an executor would do in probate, but not have to wait the court time period. Sometimes you have to wait 3-4 months before the executor can take the next step. So that's why you'll often hear about a revocable living trust. We'll talk about some other types of processes. Some people who don't have a will yet, most of your assets might be in things like a 401k, or you have a life insurance policy where you could have a beneficiary designation, and that can avoid the probate process and avoid even a revocable trust if done right, so that things pass through to a beneficiary. So all of this, part of what we like to do is when I was practicing law, clients would come in and know that they were paying by the hour, and they'd be real nervous, and they would try to go as fast as they could. What I found on the wealth management side, working with Charlie and our other advisors, is a financial advisor can help dispel how this all works, and that we'll typically have an idea of all the assets that our clients have through the financial planning process, and then we can help our clients set up the best estate plan as possible. You might still need an attorney to draft the documents at the end of it, but it's a great way to make sure everything's in a good spot. So, why plan early? There are incidents, even, one of the things that I've seen is somebody has a moment where they're in a car accident, and they might not be, they might be in a hospital for a few days, and they can't do anything. They can't sign checks. They can't, make any decisions on their own. So that's why the powers of attorney that we'll talk about in a little bit can be very useful. Once you get things in place too, you can then make sure that, the other parts of your financial plan should be, do you have the adequate risk management, right? Do you have the types of insurance that you should have for all whether it's life insurance, property, casualty, and so on? And then how does that relate with your estate plan? How about, the fact that income is your biggest asset when you're younger, you're accumulating assets. And in the future, your estate plan is more about preserving and protecting what you're making right now. So the focus on your estate plan should be to make sure it's as efficient as possible. Should be the kind of thing you only have to think about, once a year, maybe once every 2 years, and then it's in place, and hopefully it's not needed for many, many decades. So one of the things we thought we'd do is just talk about, a typical type of new client that we'll see. And his name's Alex, and he's a physician, recently married, making money, but has a lot of debt, right? And doesn't have an estate plan yet. And so, we come across this quite often, and, sometimes a young professional might think, oh, there's so much I have to do. But really, as we go through it here in a little bit, you'll see that there's just a few things that, should be done for sure. And then there might be some more advanced things based on your situation and your family's situation. But we thought we'd start with this case study. Like I mentioned in that slide a few back, the fundamental estate documents, the core components of an estate plan, should always be a last will and testament. And in that's where you appoint an executor, and that only kicks in when you pass away. So the last will and testament is for your assets that are stuck in your name at the time that you pass. The other thing that a last will and testament does is if you happen to have young children who are minors and you pass away, and there's no other parent to parent, or if both parents were to pass away, your last will and testament can designate the guardian of your children, and that'll usually be a rebuttable presumption. The court will usually go with the parent's last will and testament as to who they want to be the guardian. That tends to be the biggest thing for procrastination. A lot of clients get stuck on that. And my guidance on that is, if somebody snaps their finger and say, who do you want to be the guardian when you and your spouse or you and your partner are gone, or you and the other parent, you usually have a name that comes out first. Go with that, and in the future you can always change it. But just get it done. The revocable living trust, like I talked about, that tends to be something when folks hit about their 40s, 45, that makes a little more sense, especially when you get to the point where you're not going to have minor children anymore. Then the living trust can, and you're getting closer to when your estate might actually happen, the living trust can be a great option. And most people, 45-ish or so is when it's really recommended to start thinking about. A power of attorney is a document that you give an agent, you as the principal, and you can have a backup as well, but you say, this person, if I can't speak for myself, let's say hypothetically I'm in a coma, and somebody needs to file an insurance claim, somebody needs to take some money out of my bank, all these things that usually happen whenever institutions find out that you've lost capacity, they will freeze accounts. And then, if you call in somewhere, they'll say, you're not the name on the account, we can't talk to you. So this power of attorney is a document where that person with that document can actually act as you and make decisions for all your financial decision making across the board. Likewise, a healthcare power of attorney, sometimes called a medical power of attorney, or a healthcare proxy, is a document where if you can't make medical decisions on your behalf, each state has a statute that says you can appoint someone to make those decisions, and you can, of course, name a backup. The advanced directive part of it, sometimes it's the same document, sometimes it's separate. It also has a nickname of a living will. That's something where you can state your decision making if you're in your final moments, where like maybe some form of like a respirator or something is keeping you alive. You can write down, this is how I want this to be turned off, whether it's right away or at a certain amount of days after doctors have decided that this is the only thing keeping me going. You can also just give that decision making to your healthcare power of attorney. And then, of course, insurance. Good to know, and we'll touch on all of that. So I'm going to hand it over to Charlie now to continue with the presentation.
Great, thanks, Jason. So Jason touched a little bit on this, about the difference between financial and healthcare powers of attorney. But again, really important documents. From my perspective, or from our perspective as advisors, really the base level documents, the will and the power of attorney, are really the items you want to really focus on when you're thinking about your financial plan. So in this case, talking about the durable power of attorney for financial and healthcare needs. Without this document, or without these documents in place, in all likelihood, especially as an adult, you're going to have somebody that you don't know, doesn't know you personally, and more importantly, that you don't trust, that could end up making decisions for you on your behalf. So thinking about healthcare, I would prefer not to have somebody I don't trust making decisions about my healthcare plan. Similarly, financially, right? What bills are being paid? How is the mortgage getting taken care of? Things of that nature. You want to make sure you have somebody that you trust that is in these roles to make the decision that you would have made for yourself. So really important to have those documents, in place should something, God forbid, happen to you. One other really important thing as well, thinking about ages, right? At the age of 18, you become an adult. And so no longer are parents allowed to just get access to your medical records, as an example. So making sure that those documents are set up is really important in terms of decisions being made that are in your best interest and that you would have made yourself. I'm gonna click to the next one, Jason. Perfect. All right. So Jason touched on this, but two types of insurance. We'll start with disability insurance. This is often, and Jason, correct me if I'm wrong, but in all likelihood, this is often the most ignored, looked over piece of estate planning that most people don't have, is disability insurance. Everybody thinks they're healthy. Everybody thinks they're going to be able to work as long as they want to work, and be as healthy as they can. But in all likelihood, the chance of something happening to you, whether short-term or long-term, having a disability that stops you from performing your job could happen, and is often, a higher likelihood than death, for sure. So having a disability policy in place is really important. And most people don't understand this, but when they look at their core documents, their core benefits from their employer, yes, there is short-term disability worked into those documents. However, that benefit, not only is it really only on average 60 to 65% of your actual income that you're getting from your employer, but it's also taxable. And so having a disability policy layered on top of what you get from your employer is really important to keep your income at the level that you were at previously, prior to going in or having some sort of disability. One other piece that's really important that you should be working on with an insurance advisor, having own occupation coverage really matters. So the classic example is, in this case, Alex, like Jason just mentioned, he's a physician. If for whatever reason he was unable to do his job and he had an any occupation policy, well, he might not be able to be a doctor or a physician, but he could go, sit behind a desk and do clerical work or whatever it may be. But maybe not nearly have the amount of income, this 250,000 that we gave an example in that case. So having own occupation, meaning that if you were injured and unable to perform your own occupation, then you still get the full benefits. So really important to have that type of policy layered in along with what you get from your employer. Life insurance, again, another important piece of insurance that is really important for particularly young people, young families to have in place. So if you have dependents, young children, or maybe if you have nieces and nephews, or even parents that you are financially responsible for that rely on your income, having some form of life insurance is really important. The really easy thing to think and protect against is should you pass away, having a policy that covers any form of debt. So think about a mortgage, car payments, whatever these day-to-day costs that you have that should you pass away, that your spouse or anybody that relies on you, that income leaving would put them in a tough spot. Oftentimes for young people, getting a simple term insurance policy is cost effective and the way to go. I personally use term insurance to hit the base case needs, make sure my mortgage is covered, make sure that education expenses will be covered for my kids. Having a term policy is really, really simple, really easy, and really cost effective to have in place to make sure that you're getting all the coverage that you need. Beneficiary designation. So this is really important and oftentimes another overlooked piece of an estate plan that people don't truly understand. So as Jason mentioned, you have two types of ways that beneficiaries are designated, either through the will or through your revocable trust, or beneficiaries set up on your retirement plans or life insurance. Something that's really important to understand is that if you have a beneficiary designation set up, let's give an example as on your 401k plan at work. Let's say you were married or even prior to being married, maybe you have a sibling listed as a beneficiary or your parents listed as a beneficiary, but then you do get married in the future and you end up having children. If you don't update your beneficiary on those accounts, the beneficiary control will go over the top of a will or trust. So that's obviously not what you would, unless it is, but in most cases, it's not the case that you want to have your sibling or a parent listed. You want your spouse, you want your children to make sure that they're getting those dollars and that they should be getting or being the beneficiary for. So it's really important to review these documents, every year or so to make sure that the beneficiary designations are set up on those plans and align with your overall financial plan. All right, Jason, I'll turn it back over to you.
So, the outcome obviously is, what we'd hope everyone has is in Alex's case, maybe not enough property and not young enough that he doesn't need to create necessarily a revocable living trust, but a last will and testament, financial power of attorney, healthcare power of attorney. We typically recommend, some people might say, well, I have two siblings, maybe I'll name both of them. That can work, but it can be better to pick one person. It makes it easier. So the powers that be know who the decision maker is. Your siblings could still talk, or if you have two parents that you might name the one, and then have the other as a backup, just so that there's one person. Obviously, we talked to Alex about buying disability insurance. As Charlie mentioned, if it was the right thing to do, he might get the own occupation, so that let's say he was a surgeon and couldn't operate anymore because of accident that happened, he could have the disability policy enforced, and they wouldn't have to go do a desk job or something and not get paid out on that disability policy. We'd review and update beneficiary designation of the various policies, if he has life insurance, if he has IRAs or 401ks, things along those lines. And that would avoid the court involvement if something ever happened in the future. Those documents are available. One thing to make sure is that the people that you name have copies. Used to be that everyone would do it in paper and everyone would have things. We still say it's a good idea to hold on to the originals, but most people will email all the people they name and say, hey, you're my power of attorney. Here's a copy of the PDF. If it's ever needed, it should be accepted, and so on. And so, the action plan that we would say is, but by all means, if you have any questions about this, or, we'll have sometimes more complex issues come up. People will say, I might have a potential inheritance coming in, or I have, a rental property, and what do I do with that? Does it go into an LLC? Things like that. All those types of questions. If you have any questions, we'll provide Charlie and my contact information. We're always happy to kind of talk to people about, their situation and see if they need to go through financial planning, maybe one day become a client, but also just make sure that you feel secure, that you have the right things in place. The creation of the core documents, there are some ways these days to not necessarily go through with an estate attorney. But of course, working with an estate attorney is usually, the recommended route. So you want to get those documents put in place, review any insurance you have, make sure you have the right types of policies, for the property that you have, and make sure that it's, adequate, as Charlie mentioned, for, if your income was going to be lost, you should look at your life insurance plan and say, what would be the amount needed over the next, couple decades so that I'm covered. And then make sure your beneficiaries are reviewed and updated. And then every 2 to 3 years, look at things, make sure they're good. Obviously, if there's a major life event, a death in the family, a divorce, a birth of a child, and anything, or if there's an issue, we get a lot of calls, and we really help well. Sometimes people and their families will have someone who might have some special needs, or might have some mental or physical issues that they're not quite sure they'll be able to fully manage assets as a beneficiary. Those are the types of things we're happy to talk through, and there are options out there. You don't have to name a person as a trustee. That sometimes there's professionals, there's trust companies that are in this work, and we partner with some great groups that do those types of work. So anything that can be helpful, or if you have any questions at all, feel free to let us know. And so with that, we'll pass it to questions, and if there are any, Charlie's going to take a look in the chat panel, and then I'm going to put our contact information up.
Awesome. Thanks, Jason. We've had a couple questions come in. The first one is about how much life insurance should I have? That's a really great question, and is ultimately different for everybody. Typically you get life insurance in amounts of 250,000, 500, $1 million. It's usually round numbers, but it really all depends on what your circumstances are. The easiest ways to think about it, and the base case way to get started on what the amount should be, is thinking about, okay, what are my debts and what are my expenses in the future? So again, mortgage, education costs, things that you're going to have to pay for. And on that note, one piece of advice that I often give to young families is you should be getting a life insurance policy for both spouses. So it doesn't matter if it's the higher earning spouse or the only income earning spouse. Both spouses really should have some type of policy. People often think that it should just be the higher earner, but it really should be, if you were to pass away, or if your spouse is to pass away that either doesn't work or is the lower income earning spouse, you're going to have your costs, your life is going to get way more complicated in terms of taking care of children and what that all looks like. So thinking daycare or, some sort of help in the home. There's lots of costs that come with, even if it's just one spouse that passes away. So having both spouses have some sort of policy is really important. And again, it depends on your certain situation. But the base case is to think about the debts that you have and then go from there in terms of what your future expenses look like down the line. Our second question was, what's the best way to consolidate and store all of our documents and do it safely? Really, two ways to do that, or two ways you should be thinking about it. One truly is to have hard copies that you are storing in a safe place. Oftentimes, an attorney that you have If they're the ones drafting the documents, they might keep it in their vault or their safe, a copy of those hard copy documents. But also, you should typically, people that have gone through this, they've seen the giant binder that an estate planning attorney will provide with all the documents organized. It's good to have copies of those stored somewhere in your home or a safe place, and make sure that your power of attorney knows where those documents are should you need them. Another great way to have these documents saved is to use some form of a cloud-based software like Dropbox or whatever it may be that you use, particularly from the standpoint that you might need to be able to, or your power of attorney, excuse me, might need to send those documents somewhere quickly, right? You might need to send them to a physician's office, or need to, if you get some sort of loan that has to be taken care of, you want your power of attorney to have access to those documents quickly. So somewhere that you can store them safely, but be able to send them via, email or whatever it may be. Another question here: what happens if my parent becomes incapacitated and we don't have power of attorney documents set up? What are our legal options? Jason, you want to take that one?
Sure. As we mentioned, at any point, if someone is incapacitated, let's say they've gone, they're in a hospital and they're non-responsive, but they're still alive. That's where you'll hear different states have different names for it, but you can petition a local probate court where your parent lives to be named as a conservator. Sometimes it's called a guardian of the person or a guardian of the estate. And what that is, and you'll sometimes hear about that with like celebrities who, are troubled, and someone will ask to be able to take over their financial matters because they can't make those decisions for themselves as an adult anymore. So there's usually an on-call probate court judge, and, within 24, 48 hours, you can typically get an emergency hearing and get appointed. It's expensive, and it's usually recommended to have an attorney guide you through that process. So that's why, there are remedies that are out there, but it's pretty simple these days to get a power of attorney, where you can be named, and then someone else, maybe another family member, as the backup. So that's what I would recommend is, by all means, if you have the chance and you can get those documents created, do so. Otherwise, if you feel like somebody has already lost their capacity and they can't sign those documents, there are attorneys out there. We tend to look for ones that specialize in either elder law or special needs planning. And of course, you can reach out to us. We have contacts, in most of the markets where we operate, where we can help make some connections as well.
Jason, I got another one for you. At what age do I need to begin preparing wills, power of attorney, trust documents, all the base estate planning documents?
Yeah, I would say it's never too early once you're an adult. So most people, like Charlie referenced there, we have a lot of our clients who they'll have children go off to college or university, and they find out for the first time that, if their kid ends up in the university hospital, and they try to call, they can't even be told if their kid's an actual patient. So that's why we recommend at an early age, get those powers of attorney put in place. Until you have any kind of assets that are worthwhile, I'd say maybe $50,000 to $100,000 worth of assets. Once you start to get to that point, it can't hurt to have a basic will that just says, if I pass away and somebody needs to retitle and set my assets and settle my estate, you can create a will, in your early 20s is a good idea. Again, most people, like even for me, as you're contemplating marriage, or sometimes when you're about to have your first kid, it gets very real, and you're like, not only am I worried about my assets, but I want to make sure the right person raises my new child, or, and that someone, and in my case, I looked at it and thought, do I want the same person who might be the guardian of my child, if me and my spouse are no longer around, to be the person who's in charge of the finances? So in some wills, people will say, we want a trust created if any of our children are under a certain age, maybe it's under 25, under 30. And as long as they're under 18, we want this person to be the guardian. That person doesn't also have to be in charge of the finances. In some families, there might be somebody who's more financially acute who could be the trustee of the trust for the children, manage your assets. And that could be the death benefit from life insurance, the value of the equity in your home, your bank accounts, your IRAs, so on. And then someone is raising your children, and that trustee can provide the guardian the necessary amounts of money for health and education and food and shelter, but they don't necessarily have to hand that money over to the guardian. Or it could all be one person if you have a good choice. So I'd say the sooner the better, for the short answer to that question.
Great. Thanks, Jason. We've got one last one that I'll take. What should I do if my estate planning documents no longer fit my current financial situation? Well, first of all, this is very common, and for good reason. Hopefully, it is the case for everybody, right? Your income goes up, you're saving more, you're potentially getting married, having kids. There's a variety of reasons as to why this would change, all for good reason. The first recommendation would be, particularly if you're moving to a different state for whatever reason, to make sure that you're contacting an estate planning attorney in the state that you live, where you have residence. Every state is different. Michigan, Colorado, Florida, New York, every state has slightly different rules that are part of their own state's estate planning law. So make sure that you have your documents drawn up in a state that you have a residence in. Decisions that you made 5 years ago could no longer be the case. Real world example for me, after my wife and I, were done having kids, we went back and reviewed all of our documents that we had done 10 years prior, and my wife's engagement ring was listed to go to my niece. Well, obviously we'd like my daughter to have that engagement ring at this time. So that was a simple adjustment that we made, within our estate plan. Something very, minor, but still, you will change your mind. Decisions, for whatever reason, your relationship with the beneficiary, or how you want your assets to be split up at your passing, those things change all the time. So we often recommend, particularly when you're younger, to be reviewing those documents, every 3 to 5 years. You really should be staying on top of that. Your needs, your wants, your wishes will likely change over time. As you get older, that will likely, reviewing those not as often is probably fine. But anytime you're moving, making a major decision, it's completely normal and happens all the time. I would say on average that most people are updating their basic estate planning documents anywhere from 3 to 5 times during their lifetime. It's a normal part of life as your wishes change over time. Well, if there's any other questions, Jason and I's contact information is listed here on the slide. But again, thank you very much for joining us. We appreciate you taking some time on your lunch hours to sit with us and learn a little bit more about estate planning. Again, if you have questions, please feel free to reach out to us directly, and hope you have a great day.